Most cases are settled. One reason is that the process takes so long and it's so expensive. And in most cases, they're all or nothing cases. Either the will is valid or it's not valid, or the deed is valid or it's not valid. And if you don't settle and you go to trial, the judge has to decide and pick one side as the winner and one side as the loser. That's high stakes poker. That makes people nervous, both the attorneys and the parties. Frankly, nobody really knows how a case is going to turn out. You think you may know, or you think you may know your odds, but those are just odds. So most cases do settle. The modern trend today is to do mediation. In the old days, the way the settlements would happen is the attorney would call the other attorney and say, we'll give you so much. And 2 weeks later, that attorney would call back and say, I discussed that with my client and I think you're all wet and we want this much. And that process would go on for months. Now we do what's called mediation. Mediation is typically an all-day structured settlement negotiation, typically with a retired judge or a senior attorney there to act as a neutral, as a mediator. It's important for another reason too. The parties are there, and so they get to hear the other side directly without it being filtered through the other side's lawyer and then through their lawyer and then to them. And they get to express themselves directly, if they wish, to the other side. You know, when you said this, that hurt me, or when you did that, or why did you do this? You don't have to do that in mediation, but you have that opportunity if you choose to do it. And typically at the end of the mediation session, there is a written settlement agreement. So we participate as advocates representing our clients in mediation all the time. I have been trained as a mediator, and I do some mediations as a mediator. My litigation practice keeps me pretty busy, so I don't do too many mediations as a mediator. But I find that when I do, it gives me really invaluable insights so that the next time when I'm in the other chair as an advocate, I kind of know a little bit better what the mediator's thinking and how to better present the case. For more information, call me at 510-463-3170 or visit my website at triaylaw.com.